There you are. Okay, you can start whenever you're ready.
Good morning, Your Honor. May it please the court. My name is Joseph Herbert, and I represent the appellants, Glenn and Deborah Renwick. I would like to request 3 minutes for rebuttal. We have today before the court an important question of law and an important issue that should be determined in order to protect homeowners in this state. The matter is also a question of first impression for this court as far as the parties are able to determine, and that is whether a construction contract single and solitary scope of work under a construction contract can be severed so that portions of that scope of work can be pulled out if those portions are constitute unlicensed contracting activity, to allow the remainder of the contract that was not either unlicensed or exceeding the license of the contractor to move forward, and allow that contractor to, in essence, contrary to the terms of Florida statutes 49-128, enforce that contract either in law or in equity. Appellants would obviously contend that to allow that would run contrary to the direct and plain language of Florida statutes 49.128.
Mr. Herbert, before we get to the specifics of this contract, let me ask you. I know the court below held, I guess on summary judgment, that this contract came into existence when all the supporting documents were done, the scope of work and so forth, which was a significant period of time, I guess, after the contract was executed, correct?
Yes, Your Honor. It was several months. It was in January, the original contract was signed. In May is when the original scope of work was prepared and issued. Well,
you know, I'm looking at the statute for 89-128. And it says, for purposes of this section, the contractor will be considered unlicensed only if the contractor is unlicensed on the effective date of the original contract for the work, if stated therein, or if not stated, the date the last party of the contract executed it, if stated therein. And in both of those situations, both of those dates, are they not in the contract January 16th, 2017?
No, Your Honor. That by the terms of the contract itself, the January contract states in its terms that it is not complete. It is not a complete document until it has
well, actually, it doesn't say that, except it says that the contract documents will become part of the contract. But as I read this, upon the execution, as I read the contract, upon the execution of that contract, there were some duties that flowed back and forth. The Renwicks had to pay some money, and the contractor had to begin working on getting the contract documents together and working on the permitting process. So if I read the statute, see, even if the contract doesn't specify an effective date or signature date, it hinges on the first date upon which the contractor provided labor, services, or materials on the contract. And isn't this working on the construction documents and the permitting process services under this contract?
No, Your Honor. We would,
and I know I'm throwing you kind of a curveball here, because, but you know, I have some concerns about the determination that for purposes of this statute, the contract date was later than what's reflected on its face.
to answer Your Honor's question, no, the construction contract in its entirety contemplates services that are the construction or remodel of the unit. There are not separate design. There's not a separate design phase where part of the construction contract was coming up with the contract documents. There was no scope of work within that original January document. So there was.
What was then the import of that January document?
The import of that January
I mean,
document.
you're trying not to call it a contract, I guess, but it says it's a contract.
It does, Your Honor, although it suggests that that becomes the contract when it has the design documents. They were not going to move forward with actually, this is, to some extent, we're delving into record and to the very edges of it, but the contract services began after the scope of work was developed and the schedule was developed. I don't believe any of the pay applications were applicable before that scope of work was developed and put in place. So there were no services rendered that were payable until the scope of work was developed and it was put in place, and that portion of the contract was complete and moved forward. I would also suggest to the court that appellees have not appealed the determination and the finding of fact that the contract was complete and executed as of May, when that scope.
I do get that, but under the right for the wrong reason principle, I think it is pertinent to your position as well, is it not? This question, whether the provisions of 489-128 applied in this instance. That's why I'm bringing it up.
Yes, I understand Your Honor's point. I would suggest to the court that argument was considered and rejected by the trial court, and the reason is because we cannot determine whether Murray Homes was licensed to perform this work on the basis of the January document, because there is no scope of work under that document. There is no outline of what they're going to do or what services they're going to perform. So until
which is kind of a problem with this statute, is it not?
No, Your Honor, I think
because it says the date it's executed or its effective date as set forth in the contract. So for instance, even if you add all of the scope of work into the contract documents, right? The contract still says the effective date is January 16th, 2017, and that is the date that the statute refers to. So I acknowledge that, as a practical matter, it's problematic, but in terms of the strict construction of the language of the statute, which I think you from your position would require a forfeiture, and therefore I think would need to be strictly construed. That's all I'm saying. But I don't want you to spin your whole argument on this, because obviously you have different positions. But
well, it's an important issue, Your Honor. We want to make sure that we address it, because sure, there can be no determination of whether Murray Homes was properly licensed to perform the work until that contract, which by its terms encompasses the enumerated specifications and scope of work. And until that document becomes a part of the contract, there is no way to even determine whether they would have been licensed to do the work. And
I get that, but what you're suggesting then is we have to then ignore the express language of this statute because of that circumstance.
I would contend that there is a conflict in the way that the effective date is described in the contract. The contract contemplates an effective date at that time, but also contemplates that it is complete, and it is a complete document when it has a scope of work. So I'm not necessarily suggesting that the court has to ignore any portion of the statute. I think the court may have to ignore a portion of the contract that conflicts with the direct portion of the contract that the trial court already made a factual determination that is undisturbed on appeal, that says this contract was effective as of the date that it had a scope of work. And that is the effective date by the terms of the contract because it incorporates and includes that scope of work, which is contemplated to be created later. So the only portion that will need to be ignored will be the portion of the contract that states its effective date, which is in direct conflict of the more specific inclusion of a later contemplated addition of an actual scope of work. The contract cannot be considered complete until that scope is developed and included.
Well, we don't need to be arguing about this. I think that there is a, if we were litigating over in a common law situation, whether there was the existence of a contract, I think your position would be quite strong in that regard. But where we're talking about the application of a specific statute that calls for a forfeiture and it has specific terms about what date it applies to under the circumstances, I think that might be a different matter. However, moving on, if I understand your position generally, and tell me if I'm wrong, is it your position that this statute requires forfeiture regardless of the general test for this sort of thing, which is the illegal portion is, whether the legal portion of a contract goes to the essence of it?
I think the statute itself makes clear that it does not provide for a severability. However, I understand that I think arguably severability, I don't think it's contemplated by the statute. I think the statute makes clear that any contract that includes illegal services is void and cannot be relied upon in law or in equity by that contractor. And the Supreme Court has given us guidance on that issue in Earth Trades Inc. v. T&G Corp. 108 Southern 3rd 580 from 2013 in declaring that it essentially is a draconian measure, but the reason for that is to protect the public and to prod contractors into obtaining the required licensure. So I think it is not by the terms of the statute subject to severability, but if it were, under the case law, provide first that the contract did not contain a severability clause, which I think is a very important element. Third, what is attempting to be severed is not a provision of the contract. For instance, all the cases cited by appellees in the response and the answer brief are situations where there are separate scopes, where there is a purchase of a property and then development of the property. In all those instances as well, there are separate payment terms that apply to those separate stages of the contract, where you have a separate entire provision that could be excised out. That's not the issue here. In this case, we have one scope of work, and what we're attempting to do is cherry pick out, not in the contract specific words, but tasks. So we're subdividing at a very granular level within a provision. We've not been able to find a single case that allows picking out small portions of subdividing out a scope or a portion of a portion in order to sever that. And in fact, that approach was specifically rejected in Schatz v. O.P. Winter Haven Inc. 86 Southern 3rd 456, another Supreme Court case of 2011. In that case, the court said, while the agreement did contain a severability clause, the clause allows provisions, not portions of provisions of the agreement, to be severed. So I think when we talk about the essence of the contract, this structural work, and we're not talking about work that was incidental or ancillary. This was work that affected both the above, below, and side-to-side structure of a penthouse in a mid-rise condominium building.
Yeah, but it's true, is it not, that when the parties entered into the January 16th agreement, whatever you want to call it, that work was contemplated to be performed by another contractor, correct?
There were discussions about that, Your Honor.
Well, there were discussions. There was an email from Mrs. Renwick that suggests she had a proposal from another contractor, and she and Mr. Renwick, we're having, doubts about that contractor. And shouldn't we then, wouldn't it be better to include it under, quote, our renovation with you? So those two things clearly I would suggest that they were separate contemplations by the parties. I mean, that as of the time the January 16th agreement was entered, your clients were figuring they would have somebody else perform this exterior work, correct?
There were
And
discussions.
change their minds.
Yes, Your Honor, there were discussions about that. I would, again, I think it's important to consider this from this context. And I think it reinforces our position about the January document in that there was an ongoing discussion and negotiation about what the contract would be, what scope would be included, what services, and how much.
Well, my point is that the general test is what is the essence of the contract, and you're talking about it being the essence of the work. And clearly the parties contemplated, I would suggest, that those were two separate aspects of the work and that they could have contracted separately.
They certainly could have. I mean, in fact, Your Honor, they could subcontract entirely every piece of this remodel with separate contractors had they wanted to do that. But the issue is when we had that was a crucial part of the work that was being performed on this project. It represented 70% of the pay applications on this project, represented work that was structural in nature. So yes, while it was added in as part during the period of time that this contract was being finalized, it was always a very substantial portion of the work. And it was always a very substantial portion of this scope of work, the only scope of work that ever existed for this contract. So it's not like there was a separate scope that was developed and this was added later. This was an integral part of the very first scope. And I see I'll be going into my rebuttal time a little bit.
Well, I have contributed significantly to your use of the time, Mr. Herbert. So I'll give you an extra minute in any event. So
I appreciate that, Your Honor. I think from the standpoint of the contract, it would defeat the statute 489-128 to allow contractors or handymen, whoever, to just write up a short agreement that says we will come up with a scope later, but we're going to do services in your unit, and then to sign that, and then later when they figure out what they're going to do, it includes a massive amount of structural work that if performed incorrectly, I mean this court obviously knows, we as members of the public know of tragic issues where we have mid and high rise units where they have structural issues. This is a direct and imminent threat to life and safety of the public. And to allow contractors to skirt the requirements of being properly educated, properly licensed, and to have those contractors be the ones that actually sign contracts to perform work threatens the public safety and runs directly contrary to the public good. The idea that this contract could be taken in pieces it is nonsensical, only to the extent that there could never have been a provision of this contract that included how long it was going to take, what it was going to cost, what the specifications were, what the actual scope of work was, until those documents were finalized a couple months later. During that period of time, that was a full discussion, and the parties probably could have just walked away from one another if they didn't agree on a scope. But so that contract,
Mr. Herbert, you are now like well into your rebuttal time. I just wanted to give you that heads up. Do with the time what you want, but
understood, Your Honor. So we would ask, obviously, that the case be either reversed or remanded for determination of the fact that this was unable to be relied upon by the contractor in law or in equity.
Okay, thank you. Mr. Garcia.
May it please the court, Martin Garcia, and along with Mr. France, who was unable to be with me today because of an illness, but we represent Murray Homes and Stephen Murray. And I'd just like to reiterate, as I put in the brief, Stephen Murray is an appellee, although there aren't any claims being made in this appeal. This relates only to those claims that were between the Renwicks and Murray Homes. I do want to kind of touch on some points that you made, Judge Northcutt, with respect to the effective date. And obviously, we argued that. Mr. France argued that. That was one of the main points on the summary judgment. And in sort of the ruling that Judge Walker did, where he said he found disgorgement was an appropriate remedy, he then also found that, and he said, well, I think I can also sever this out. But he then ruled that because, and he accepted Mr. Herbert's argument, that because on the date of the contract, there was still a determination to be made as to what work was going to be included. And we disagreed with that the contract was not effective, notwithstanding what it says, and that's the contract date. And we haven't appealed that. We recognize that.
And I get that, Mr. Garcia. I was proceeding from a right for the wrong reason. Because if you had appealed that and this panel had agreed with you, then the whole question of disgorgement at all would have been on the table. But
right, the 43,000 probably would have been back off the table because we were licensed.
But that's not where we're at. I was just mentioning
that's not. But I wanted to address the point that you made, Judge Northcutt, because I do think it also goes, and you raised it, which I'm going to get to a little bit, is the essence of the contract and the severance. And you pointed that out. How can the essence of this contract be for something that wasn't contemplated at the time the contract was entered into, which is the exterior work, the windows and the walls, which is what the court ultimately found. Okay, because it was a whole lot more, and I heard Mr. Herbert, but I would disagree in terms of the work that was being done. This was a complete interior remodel of their penthouse condominium. And as part of that, which originally was being contemplated being done by Spectrum, okay, was going to be the new windows, the curtain wall, all of that work that what the judge ultimately focused on at trial. And it's interesting, and I want to point out that, in fact, what happened is Judge Walker did exactly what the Renwicks asked him to do in their amended complaint. And I referenced that in the answer brief at paragraphs 37 and 38 of their answer brief. And that is that disgorge the fee with respect to the unlicensed work. And that's what Judge Walker did. Okay? And to say, and I want to address the point that Mr. Herbert raised, that this statute is clear. I would respectfully suggest this statute is anything but clear, because what the statute talks about is unlicensed contractor and scope of work. Okay, well, it is without dispute that Murray Homes was a licensed contractor. They were a licensed building contractor. Now, granted, within that definition, there's a carve out with respect to what they can't do that a general contractor can do. Okay, and they can't do anything that affects the structural members of the building. Okay, and it took an entire trial to determine what that was in this particular instance, because as we pointed out, and we didn't appeal this because there was evidence on both sides. We pointed out, there was evidence that showed that the work that was done didn't actually affect the structural members. The judge did not agree with that. He accepted Mr. Herbert's witnesses with respect to that issue. But to say that, well, at the beginning, everyone knew this affected the structural members of the building and therefore you were unlicensed is actually, it doesn't jive with how this transpired, okay? Because that was added later. And that really goes, I go back to the severance issue. But I also want to point out that not only is the statute not clear, and Judge Walker, consistent with what Judge Corrigan did, and we find it rather interesting that in the reply brief, there's no reference at all. And I get it. It's a trial court decision from the Middle District. Judge Corrigan, now the chief judge of the Middle District, though, he did the same analysis back in the Full Circle Dairy case. And he came to the conclusion, and I want to point out kind of a little bit of difference in the statutes, some of the statutes at the time, but he came to the conclusion that you have to look and see what the work that's being done. He has to do what Mr. Herbert now takes issue with, which is taking out and saying this work is licensed, this work isn't licensed. And I would suggest the reason why is because when you look at the public policy behind this statute, okay, it's not allowing individuals or entities who are not licensed to do work get paid for that work. Well, that does not jive with the entire theory that Mr. Herbert is advancing here, which is if you do any unlicensed work, it voids the entire contract.
Well, and if you just glance through the statute, it seems clear, but if you really start thinking about it, it's got some problems. For instance, it only applies if the contractor is unlicensed on the effective date of the original contract for the work. So what happens if the change order takes them into some unlicensed territory? Statute doesn't really speak to that, I don't think.
It doesn't speak to that, Your Honor. And I would also say that you have to factor in, and we've cited it and Mr. Herbert responded to, but you have to factor in analyzing this statute 489-113-9A though, which we've cited in our answer brief. And what's important about that statute and Mr. Herbert's argument in his reply brief is, well, all that means is that you can be the prime contractor, that nothing in this part, and the part we're talking about is the entire 489 Part 1, that nothing in the part of that statute prevents a primary contractor from contracting for work that a majority of which is in the scope of the license. Okay? And then it says, or subcontracting the remaining portion of the work. And Mr. Herbert's argument in his reply brief, and obviously we can get a chance to respond to that, is really that means and. Okay?
Well, I mean, for purposes of the policy, maybe it should have been, but it's
well,
not.
what's interesting, Your Honor, is I went back and did review the statutory history of that. And prior to 2007, it did say and. If you look at the history of that statute, when it was first enacted in 1990, okay, it talks about the bulk of the work and not the majority. And then it has and as the modifier with respect to instead of or. In 2007, for some reason, and there's no legislative history with respect to why that came about, but that was changed from and to or. Okay, so the position that Mr. Herbert is taking with respect to 49113-9A is directly contrary to what happened with this statute. And what this statute says is that you can be a prime contractor and enter a contract, as long as the majority that includes some work beyond the scope of your license, as long as you're doing a majority of the work. I would suggest if you're not doing a majority of the work, then you are then contracting to subcontractors. But the evidence here very clearly showed, if you just do the calculation as to what Judge Walker found, okay, and the evidence before the court is this was a portion. And Mr. Sollenberger, he got him to say several times, this was substantial, this is substantial. And that's true, but this was so much more than the windows, exterior windows and exterior doors. Okay? This was a complete remodel of the interior of this unit. Okay?
Well, to that
Garcia.
point, go ahead. I'm sorry, Judge Smith, go ahead.
Yeah, my question is this. So is it fair then to say that while this, I'm going to call it the unlicensed work that we're talking about, was complex and substantial, it wasn't the majority of the scope of the entire project? Is that fair?
And I think that's borne out, Judge Smith, by the analysis that Judge Walker did when the evidence came out as to what the plaintiff, in the case of Renworks, were alleging was the unlicensed work. Okay, and then when you look to see how that, and I would point out that that disgorgement of the fee, that was even in ordering the windows. The very first change, the very first purchase order, the invoice that was submitted, had a purchase and a deposit for the windows. And Judge Walker said, well, that's tied to the windows. So yeah, I'm going to include that in there. So I would suggest that all of the evidence showed that a majority of the work was for the licensed portion. Okay. Yes. Now, even if that's not the case, I still don't think 489-128 reads the way that Mr. Herbert does. It says if there's any taint whatsoever of unlicensed work, it voids the entire contract. Legislature could have said that. Absolutely could have said that. And what the court has interpreted, Judge Corrigan in the Full Circle Dairy case, and I would suggest courts from other jurisdictions as well have talked about is look at the public policy behind this. Okay? And the public policy is do not let people do unlicensed work. And Judge Walker was all over that, honestly. If you read his rulings, both on the summary judgment and with respect to his oral pronouncement, he wanted to protect the public policy. And that's why he then said there's going to be disgorgement if I find any portion of the work was unlicensed and we can identify what that was. So, and I would suggest, Your Honor, you can look at, because this is a cost plus contract, this was every cost, all work that was done are itemized in those draw schedules. So you're able to tell what was, and Mr. Sullenberger identified that at trial as to what that work was. So yes, long way to answer your question, Judge Smith, but I do think the evidence that came forth in this trial was very clear that the majority of the work, okay, which is what was being contemplated initially before Mrs. Renwick asked in that February email that Judge Northcutt brought up, gee, can we include this work that Spectrum was going to do in this as well? That a majority of the work was licensed work for which was in the scope of Murray Homes license. Hope that answers your question, Judge Smith.
Thank you.
I brought up 489 113A, and I'll point out again the disjunctive nature of the or. And so we believe that provision in and of itself shows that the argument that's being made, which is if there's any portion of the work that is unlicensed, it makes the entire contract unenforceable and illegal, as they like to point out, is just contrary to the statutory scheme of 489. Let me address though the severance issue as well. Judge Walker, in summary judgment, found that he denied summary judgment and said that he thinks there could be a severance with respect to this work that was being done. And I would suggest that part of that analysis is exactly what you were saying earlier, Judge Northcutt, is that work was added on. So you could kind of see what's the work that is affecting the structural members of this building. And that's the analysis. And it was a pain. I didn't sit through it. I was not trial counsel. Mr. France was, but I provided the transcript. And as you can see, Judge Walker went into great detail in his oral pronouncement, both as to the work that he found was outside the scope of the license, and then correlating that work directly to each one of those invoices and erring on the, as I pointed out earlier, with respect to ordering materials, erring on the side of caution, and then disgorging the fees, the 15% contractor fee that went to each one of those particular items. Okay, and the argument that's being raised now is, well, you're not allowed to do that as a matter of law. Okay? And they're bringing in cases, and every case that they cite is an arbitration case, is whether you can sever those portions out. And a lot of those are obviously in the nursing home context. Judge Walker, and we agree then, we agree now, those cases really are inapplicable. They provide the overall analysis a court must do with respect to whether severance is appropriate. Okay? And that's what Judge Walker did.
They apply the essence of the contract test.
Correct. And even Judge Corrigan points that out, where he says, well, this is the construction of a $900,000 building. And so we need to determine whether that goes to the essence of the contract. Okay. And the point here is that if this
whether the improper portion, if the proper portion didn't exist, you could still have the legal portion.
Correct. Yes. Yes. And what's interesting about this is that if we were solely doing what Spectrum, the original contractor that the rent, if that was the scope of our work and that was it, then I could see their argument. Okay. Then their argument might apply, but there was so much more to this that the court could then look at it, and as the court did, and say that based on the evidence, and that we do have an issue, we have a dispute with respect to the standard of review, and I think this, we think the standard of review from a legal standpoint is just whether, if there's any taint of unlicensed work that declares the whole contract unenforceable. But in this instance, whether severance is appropriate is more of a competent substantial evidence, because it is clear that while he, on summary judgment, said, I think I can sever it, when he came back in his oral pronouncement, he made it very clear that the way the evidence was presented and that the way the contract documents, the final contract documents reflected, that it was, although painstaking, that he could do that. And that's the point of severance, because if we go back to the whole public policy position here was what Judge Walker said is, I'm not going to allow Murray Homes to be compensated to get a contractor's fee for unlicensed work. And we didn't, and we haven't appealed that. Okay? We've accepted that, for better or worse. Okay? But that doesn't mean the extension, which is where Renwick's want to take this. Again, it goes to, if there's any portion of it, and we think it's a strained reading of 489-128, if any portion of work is unlicensed, even if you're a licensed contractor for everything else, we don't think that that is the correct analysis, and we think the analysis that Judge Walker did. We disagree with his analysis with respect to the effective date, but as pointed out, we haven't appealed that. We have raised, instead of the arbitration case, we've cited a couple of cases that deal with real estate commissions, and 475.41, which is the statute related to that. And we understand they're different, but they're overall both is, we're not going to allow unlicensed folks to get paid to enforce contracts. And 475.41 specifically talks about no contract for a commission shall be enforced. And the Hardcastle versus Cohen case is we think a case that is more analogous here, because there the trial court allowed an issue where there was multiple services being provided, and the trial court allowed it all to go to the jury. Jury comes back with a verdict that gets taken on appeal. And what the fourth DCA did in that case is says, we can sever this out. Okay? And you should sever this out, because there is a portion of the work that is unlicensed. So the contract is unenforceable with respect to that work. But the portion that is not requiring a license, there's even different. We have a license for the work that we did. Okay? But here it's in the Hardcastle case, it's talking about you didn't need a license for the other work. And the fourth district said, go back to the trial court, separate those two out, because we can't tell what that is, i.e. sever the services that are being provided, which is exactly what Judge Walker did in this case. Okay? And come back, and what's interesting there is it says, oh, by the way, the $10,000 that was paid toward the work that required a license, that's going to offset what otherwise might be found for work that didn't require a license. And again, that's the exact same analysis that Judge Walker performed here. We've also, for what it's worth, we did find other cases. The Hawaii case is the most interesting one that we were able to find, and we've cited the Schultz case that we've cited. It's a different statute, I recognize that. It talks about work done, though, and how work done is somewhat ambiguous as to what does that mean. And I would suggest that's analogous to scope of work and what does that mean in our context. But what the court there said was, if you're licensed, you get paid for the work done under your license. If you're not licensed for that work, you don't get paid for the work done for that unlicensed work. Judge Walker, and I'll wrap it up this way. Judge Walker did an extensive analysis of all of this. It would be, I think I can say this, he was trying to be fair and adhere to the public policy. We disagree with his ruling with respect to the effective date, but we haven't appealed that. But what he did is he followed the public policy with respect to licensed versus unlicensed work. And he even said that in his ruling. And the manner in which he did it, and I will point out, the allocating and taking those out, they haven't challenged the particular items. And there was competent substantial evidence as to what he sort of extracted from those. We've accepted that. So we think this is a case that rather unique circumstances that were dealt with appropriately by the trial court. and that the trial court's final judgment should be affirmed. I don't know that I have any other thing to raise. I think if there's any other questions, I'd be happy to answer them.
Okay, thank you, Mr. Garcia.
Thank you, Eric.
Mr. Herbert, how about I give you 2 minutes on rebuttal?
I appreciate that, Your Honor. Three very quick points. As we heard from Mr. Garcia, the very first invoice for services on this project was for deposit to pay for structural elements. So that there were no services prior to that. I want to address very quickly 489-113, section 9. For our purposes, the or and is immaterial. Here's why. The language of that provision states acting as a prime contractor. You cannot be a prime contractor unless you are overseeing and subcontracting work under your scope of services to subcontractors. Under section 2, you can only subcontract those scopes to licensed subcontractors, roofers, pool contractors, whoever you're sub-licensing to that you're not licensed to perform that work has to be licensed. That's provided for under 489.113. The final thing I'd like to address is the essence of the contract. As compared to all of the cases cited by Murray Holmes, we're not dealing with separate provisions with separate payment provisions. This is one provision, one scope of work. We cannot subdivide that scope and basically create a situation under 489-128 where every contract by any unlicensed contractor gets broken down to a granular level, and they only get to charge for things they were able to do without a license. That renders 489.128 meaningless, and people only get to no harm, no foul unless it's determined that they were working outside their scope, and then they just have to delete out those portions. We don't believe that that's the way that the statute was intended, and we don't believe that that's consistent with the plain language of the statute. Thank you, Your Honor.
Thank you both very much. I will note that as I read through these materials, I saw that Judge Walker was very complimentary of the trial counsel, the way the case was tried, and I would echo that with respect to appellate counsel. So thank you both very much for a nice presentation.
Thank you to the panel.
Thank you, Eric.
In order to go away from this virtual courtroom, you click the leave button on your Zoom screen and you'll be gone. All right. Our next case is, I don't know if it's Diener, Diner, and Rudolph versus Zeller. My stuff here.
They're trying to bring him over, sir.
Okay. Gives me a second to get my act together here as well.
Judge Northcutt, he initially declined my promotion, so I'm trying to get him to come back again.
Okay.
Mr. Smokley, you need to accept being moved over to the other side.